The other day, I made an appearance over on the Plain Bagel channel, which was very exciting, by the way, to discuss the legality of giving financial advice on YouTube. It's a topic that's near and dear to my heart as both an attorney and a financial YouTuber. And Richard did a great job going over many of the key issues, and I got to pitch in on one, which was good fun. And if you by chance haven't seen that video already, I'll go ahead and include a link to it in the description below. In this video, I want to take a closer look at this issue of illegal versus legal financial advice and who actually has to register before giving financial advice, because I think it's often misunderstood. A lot of this will be based off of an article I wrote recently about this very topic, so if you want to check that out, I'll include that in the description as well. And before we go any further, just as a disclaimer, I am not a securities lawyer. I'm actually a commercial real estate attorney by day, so this isn't exactly my wheelhouse. And in any event, this isn't legal advice. If you need legal advice for your specific situation, if you have a specific legal question, go hire an attorney. They can give you legal advice. And in any event, I'm only looking at federal law here. I'm not going into the state level nuances that might change the analysis. So what I'm trying to say is if you need an attorney, go hire one. But with that said, let's start from the top, and that's with the Investment Advisors Act of 1940. Let me take you back to the 20s, a time of rampant speculation and tons of debt being used to buy financial assets. And no, I'm not talking about the 2020s, but rather the 1920s. The Roaring 20s, as they were called, were one of the great run-ups in the US stock market's history and really just financial assets in general. People were spending money like mad, and money that they often didn't actually have. And a lot of this money went into shady financial instruments, among many other things, and needless to say, it ended in a pretty spectacular crash in the 1930s that we now know as the Great Depression. Well, with the Great Depression came with it some pretty significant reactions from Congress, who wanted to find a way to limit future wrongdoings in the stock market and in the financial markets in general, so they issued some pretty broad sweeping laws. These included the Securities Acts of 1933 and 1934, which actually established the SEC, the Securities Exchange Commission that we know and love today. But another act included the Investment Advisors Act of 1940, which was passed some years later. The act requires what it calls investment advisors to register before they actually go and give financial advice to others. If they don't register, then they can face some pretty severe punishments, including some pretty nasty fines. But how does the act define investment advisor? Well, it means any person who, for compensation, engages in the business of advising others, either directly or through publications or writings, as to the value of securities or as to the advisability in investing in, purchasing, or selling securities, or who, for compensation and as part of a regular business, issues or promulgates analyses or reports concerning securities. It then lists a host of exceptions, which we'll get to in a second. But notice how that definition is pretty broad in itself. We're talking about the advisability of investing in securities, and that could mean that you're for investing in something, you're saying that you shouldn't invest in something. Both of those are going to the advisability of something. So it's not as though it's all bullish or bearish on something. It can be either or. But what's a security? Well, security has its own definition under the Act, and it includes things like stocks, bonds, investment contracts, options, and a pretty broad range of financial instruments. But do realize that this does include stocks, and this can be individual stocks, it can be index funds, anything sort of in the stock market is probably going to fall under this act. But back to our higher level definition of investment advisor, that's just the advisability of securities portion. What about the for compensation portion, since that's another part of the definition? Well, the SEC defines for compensation pretty broadly to mean generally the receipt of any economic benefit, whether in the form of an advisory fee, some other fee relating to the total services rendered, a commission, or some combination, and the person who receives the advice may be the one who pays the compensation. That is, at least currently, there's not an explicit requirement that the person who receives the financial advice actually has to be the one that pays for that financial advice, which would mean that someone like a YouTuber or maybe someone who has a free newsletter that makes money on ads and ad revenue, that person might still meet this definition of the for compensation requirement. But in general, if someone is in the business of giving investment advice on the advisability of securities and they receive compensation for it, they would theoretically fall under this act. But I'm sure you didn't forget about the exceptions that I warned you about, so let's go ahead and get into those. Someone who meets all of those elements that we just talked about but falls under one of these exceptions would not have to register under the Investment Advisors Act. Moving on down the list, these include many banks, lawyers, accountants, and engineers, or teachers whose performance of such services is solely incidental to the practice of that person's profession, so they're not primarily in the business of giving financial advice. Any broker or dealer whose performance of those services is solely incidental and they don't receive a special compensation for giving that advice. The publisher of any bona fide newspaper, news magazine, or business or financial publication publication of regular and general circulation. We'll definitely get back to that one in a second. And includes a few others, including family offices, and then any person that wouldn't fall under the general intent of the act. So that's kind of the catch-all that the act includes. But the point is, just because someone receives money for giving financial advice, that does not mean that they necessarily have to register under the Investment Advisors Act. And the courts in the SEC, which actually enforces this law, have clarified many of these exceptions over the years and do realize that they are subject to change. Just as with any law and any interpretation of the law, there is a lot of wiggle room for some of these. But I definitely want to spend some time talking about the publisher's exemption, so let's do that now. Now, as a reminder, the publisher's exception says that the publisher of any bona fide newspaper, news magazine, or business or financial publication of general and regular circulation does not have to register under the Act. What exactly does that mean? That's a bit of a mouthful. Well, we actually got some clarity on this exception from a case that made its way all the way up to the Supreme Court, that case being Lowe versus SEC. This case was way back in the 1980s and was about a person named Lowe who was a registered financial advisor, had some wrongdoings and eventually lost his registration status, but then he proceeded to have a paid newsletter where he would give financial advice to the people who paid for that newsletter. But he wasn't registered, so the SEC brought forth a case and it made its way all the way up to the Supreme Court on appeal. Well, the Supreme Court said that Lowe did not have to register under the Investment Advisors Act of 1940 because the newsletter that he was distributing was general and impersonal in nature, it was bona fide or genuine rather than promotional material, and the publication was of general and regular circulation. So it met the publisher's exception. That's right, a paid investment newsletter from someone who was not registered under the Investment Advisors Act actually was okay under the Act. And I don't think many people realize the potential scope of the publisher's exception. We can kind of take the same logic and apply it maybe to YouTube videos or to TV shows or to whatever it might be. Generally circulated publications are probably going to fall under that exception, of course, if they do things in good faith and meet the other exception requirements. Because a key consideration is that the advice isn't specific to any one person. It is generalized advice, and it isn't promotional material either, so we're not talking about a pump and dump or something nefarious like that. And just to be clear, even though this exception and some of the other exceptions can be pretty broad, that doesn't give someone free rein to say whatever it is they want about securities or whatever financial advice they might be giving. But in any event, what can we learn here? The key takeaway here is that there are exceptions to the Financial Advisors Act of 1940 that would otherwise require people to register before they give financial advice. But if that person or company or whatever falls under the exception, then they would not have to register before giving that advice. And the advice need only be about securities, which includes something like an index fund. So someone who says that, hey, you can just invest in broad index funds and be great, that does not necessarily wash their hands clean from something like the Investment Advisors Act, since it doesn't really matter whether it's an individual stock or an index fund, because ultimately a share of an index fund is as much of a security as a share of an individual stock. Really, the question of what illegal versus legal financial advice is would come down to those higher level questions. First off, are they giving advice about securities? Are they in the business of giving advice? And are they giving that advice for compensation? But even if someone meets all three of those criteria, then we look at the exceptions to see if they can still get out of the registration requirement. And things like the publisher's exemption can give some pretty broad latitude in determining who doesn't actually have to register under the Act. So ideally that clears some things up. Inevitably, there's tons of gray areas in the law, especially with something like securities law, where there's new financial instruments that are created every single day. You have the question of whether something actually is a security, which for something like crypto is an increasingly relevant conversation. But this was by no means a comprehensive overview. And as I mentioned earlier, if you need an attorney and you have a question about something with securities law, go hire a securities law attorney and they can give you the legal advice that you deserve. Otherwise, if you like this video, definitely like it, since that would help the channel out a lot. And if you want to see more content about investing and personal finance topics, then definitely subscribe, since I put out new videos every single week. But until next time, take care.